Dr. Kennedy Graham.
Thank you, Mr. Speaker. This has been a long and complex process getting to where we are today on this bill. The bill was introduced last year in April. The first reading was in May. The committee reported in October. The second reading was in November. But the committee did not convene until this week, just yesterday, in fact, 7 months later. The reason for this is the sheer complexity of the original bill. It was described by the Minister for Courts as the most comprehensive set of legislative improvement in the recovery of unpaid fines, reparation and civil debt in 12 years. The amount of unpaid debt stands somewhere around $700 million. So there is a strong rationale to improve matters, and we acknowledge the intent of the government to simplify what is a complex matter, as the Minister said a short while ago, to arrive at, for example, a single definition of fines and court costs, offenders' levies and other concepts. The original bill itself would amend 4 principal acts: the district courts, land transport, summary proceedings and sentencing, and would make consequential amendments to 16 other statutes. In committee this week it was agreed to divide it into 20 separate bills that cover, in addition to these 4, others such as children and young persons, customs and excise, disputes, tribunals, family courts, personal property securities, misuse of drugs, prisoners and victims' claims, privacy, railways, residential tenancies, social security and tax. So this gives some insight into how hugely complex the changes are, and that's been commented on by both the government and the opposition already, and their ramifications across the statute book. In the first reading, I advanced the Green Party's concern that the statistics we have to hand in this country on this kind of thing appear to be unsatisfactory. We sought to research the question whether fines exacted on convicted defendants fail disproportionately on lower income groups. Neither the Parliamentary Library nor the Ministry of Justice seemed able to ascertain that fundamental fact pertaining to social equity in our judicial system. There is a paucity of sociological statistics in this country that has the effect of thwarting social engineering and legislative insight. We suspected, though, and yet we acknowledged, there was not conclusive proof available that the fines are exacted disproportionately on the lower income group, which is, moreover, correlated with age and ethnicity difference, and Lynn Pillay has just commented on that just a moment ago. We were concerned the bill would authorise home detention or even prison sentences as substitutes for, quote, unaffordable and unenforceable reparation orders. This, we believed, was inappropriate in adding strain to the already overstretched prison facilities. And we opposed the proposal of vehicle seizure and confiscation as introducing an unduly harsh penalty regime for unpaid fines. The Green Party is not represented on the Law and Order Committee and so did not make an input into the report. But in the second reading, we commented further with a view to making a constructive input. We advanced an alternative approach for unpaid fines to get alongside defaulters and ameliorate the problem through a process of consultation. A repayment system over a period of time could, we suggested, be devised that does not impose unduly harsh financial burden on people who are, in today's world, finding things tough. A supportive, rather than punitive, regime to people who are struggling to abide by judicial penalties is, in our view, the politically preferred and societally wiser route. Overall, Mr. Speaker, we saw the bill as counterproductive to the stated goal. Rather than getting more money from people, it is likely to get more social problems through greater unemployment, incarceration, alienation, and possibly racial tension. The debate in committee saw a slew of amendments put forward by the government itself designed to streamline some of the flaws that it had perceived in the bill as originally drafted. None of this is to criticise the good intent of the government in drafting the legislation, and for that matter, in its efforts to keep opposition members informed and updated on the increasingly complex, critical path it trod with the bill. We have followed the rather bewildering fate of SOPs 201 and 202 and then 243 and 244. We could not agree with these amendments because ultimately they would, in our view, weaken people's rights. Specifically, the proposed changes would strengthen the regime to allow personal property to be seized when someone might not have been convicted, yet a judge thinks they could be involved in crime, and for the incarceration of people who do not pay fines. Put simply, putting people in jail increases the likelihood they will commit further crimes. We do not think this is the best outcome for New Zealand and our communities, and so we could not vote for those changes. That said, I thank the Minister and her officials for the effort in compiling an annotated legislation guidebook and subsequently its corrigendum and then its addendum to the corrigendum. They have certainly tried to keep the faith in this procedural respect. But none of this has altered our fundamental judgment about the far-reaching shortcomings in the bill, or to be precise, the thrust of the original bill in the 20 separate pieces of legislation now before us. The Omnibus Bill fails the tests laid out in the Green Justice Policy Platform. That policy clearly states a preference in support of provisions to deduct unpaid restitution and court fines through the IRD or income support mechanisms. As I have noted, when offenders receive income support or are of limited means, they should be given a choice to either pay off fines or provide restitution in some other way. We remain of the view that the main provisions of the bill are an affront to national justice and a danger to the social cohesion of the country. As a result, we remain opposed to the bills and shall be voting against them at the third reading.